A very good evening to our esteemed panelist for the day, Dr. Rowena Robinson, and my colleague from Azaad Awaaz Sahil. Today's Samvad discussion is a two-part series conversation that we're having on the theme of Dalit Christians. And we've had this conversation with Dr. Sanal Mohan from Mahatma Gandhi University a couple of days back. And he gave us some brilliant insights into the notion of caste-based discrimination that Dalit Christians face, particularly in Kerala. In today's discussion, we plan to further this debate by exploring the constitutionalism involved and how it affects minority rights in India. So just to give an introduction of our panelists, Professor Rowena Robinson is a professor in the Department of Humanities and Social Sciences at the Indian Institute of Technology in Bombay. She's focused her research on the sociology of religion and kingship, conversion and Christianity in India. She's also the author of Boundaries and Religion, Essays on Christianity, Ethnic Conflict and Violence, which was published by the Oxford University Press in 2013. Thank you so much, Professor, for agreeing to be involved in this conversation.
Thanks very much. Thanks for inviting me.
Yeah, thank you so much, Ada. Professor, I think I'll just start with the first question. So in one of your previous journal articles titled Minority Rights versus Caste Claims, you had spoken of understanding India through a majority-minority dichotomy, being a product of the colonial rule. And you had also spoken about the importance of the Morley Minto reforms of 1919 in creating a sort of a legacy in India's legal, political, and administrative thought. So if you could probably just give us more context to this.
Okay. Yes, during the colonial period, the enumeration of the population via the census and through the categories of caste and religion allowed the cementing of these kinds of social divisions. Moreover, the British, for them, an important ingredient of their policy was dividing the population or thinking about the population through such categories as religion, as caste, and so on, to facilitate more easily the control of the territory and its people. The Indian Councils Act of 1919, which is what is called the Morley Minto reforms, introduced was intended to increase Indian participation in the legislature, and they provided for the first time separate electorates for Muslims. Now, this was the result of a Muslim representation, and the British agreed to this representation. The British feared the Muslims because of their involvement in 1857. They feared their discontent as having some sort of, as having negative consequences for the empire. And they also saw them, on the other hand, as a countervailing force, or as a counterweight to the Hindus. And so this provision then came into the statutes. This sowed the seeds. It was the 1919 Act that sowed the seeds for the beginnings of concretizing these ideas of minority and majority. Later on, the Government of India Acts of 1919 and 1935 further extended reservations and separate electorates to other sections, such as the Sikhs, the Christians, and what were then known as the depressed classes. So administratively, groups that defined on the basis of numerical, defined themselves on the basis of religion as numerical minorities were treated as one category, and they were treated as distinct from those who were defined as backward, socially and economically backward. And these were the depressed classes, who later on came to be designated as scheduled castes, scheduled tribes, and by other nomenclature. So this separation and this set of provisions has provided the legacy for a lot of political thinking and the way in which political, legal, administrative, and even popular thought today constructs categories of minorities and majority.
Okay, Professor. So can you just give us an idea about the constitutional debates that took place around the idea of the disadvantage being raised within the three minority groups? That's the religious minorities, the scheduled castes, and the scheduled tribes. And why did the elite Christian members of the Constituent Assembly at that time not raise the issue of caste?
Okay, this is it's a large question, and but I'll try to be brief. See, as the discussions on the Constitution began before independence, given the fact that India sought to be democratic and not majoritarian, and therefore fair to all those within her territory, the idea of disadvantage was discussed in relation to all minority groups, whose participation in the nationalist movement was also considered very important. The question of advantage, disadvantage, reservation, representation was then at that time an open one. It included the idea of political representation. It included perhaps the idea of some sort of economic and social measures for these groups. And there was also a sense that one needed a special office to monitor and report on matters of all these minority groups, which were taken, talked about in one category, as it were. But what happened was that once independence came, and partition happened, the mood of the Constituent Assembly changed. There was a shift in the thinking of the Constituent Assembly. And the Assembly and the Committee on Fundamental and Minority Rights worked very hard to persuade minorities, religious minorities, to give up claims to political representation in particular. And by extension, this also then became a giving up of social and economic benefits in the form of any kind of reservation. The fact is really that partition changed the narrative. And by and large, members of the Constituent Assembly only considered legitimate the social, economic, and political claims now of those who had been earlier considered backward. As a whole, they were not willing to contemplate these rights for the numerically defined religious minorities. In fact, the very idea that minority communities may also be backward, was something that was not really seriously discussed or considered seriously in the Assembly. Yeah, I think that would.
Yeah, Professor. And I think probably linking to that itself too, and this will be the third question also, Professor, to what extent did the surrendering of the benefit of reservations by the Christians help in cementing their minority rights? And also, how much did this help them in granting them more religious freedom, one would say?
Okay. Right. Okay, there are, I think what one would find that the rights that were consolidated, or the rights that were cemented, as you put it, were principally Article 25. Article 25, which is actually, which pertains to all citizens, not minority citizens per se. It pertains to all citizens. It is the right of religious freedom of all citizens. But the right of religious freedom of all citizens was obviously very paramount, of paramount importance to religious minorities. This was of particular importance. And the other two rights that were cemented and consolidated were those contained in Articles 29 and Articles 30. Article 29 ensures the right of any section of citizens that has a distinct language, script, or culture to conserve the same. These rights, Articles 29 and 30, were always spoken of as the rights of both linguistic and religious minorities, not only religious minorities. What Article 30 does is it contains a very important constitutional provision, and that refers to educational rights of minorities. It gives to all religious or linguistic minorities the right to establish and administer their own educational institutions. It further lays down, and this is really important and critical, and there was quite a lot of discussion on this in the Constituent Assembly. It lays down that the state shall not discriminate against any educational institution on the ground that it is under the management of a minority while granting aid. So it made sure that educational institutions or run by minorities were treated on par when it came to state grants in aid with regard to education. For all the minorities, including Muslims and Christians, Article 30 was crucial because it entitled them as a fundamental right to educate their children, to prepare them for life in culturally and ethnically appropriate ways, and in the language of their choice. It allowed them to provide for religious education as they deemed fit. So this cluster of religious freedoms and religious and cultural rights, religious, cultural and educational rights, I would say, this is what the minorities came away with once the question of political representation, separate electorates, social and economic forms of reservation had been set aside.
Okay, Professor. So in the same journal article, you had mentioned that the final shape of the constitutional provisions that the members accepted were a product of both compromise and consolidation. If you could just elaborate and explain why it was both a compromise and a consolidation.
Yes, that's my understanding at least. I spoke a little bit about the compromise earlier when I said that once the shadow of partition fell on the Constituent Assembly, then there was a pressure to compromise. There was a persuasion perhaps to compromise, however you like to put it. Given the prevailing sentiment in the Assembly, along with Muslims, Christians felt the pressure to give in to this sentiment. Christians were also deeply committed to the realization of a secular nation. And both these aspects for them, therefore, were pertinent to framing the decision and how they acted within the Constituent Assembly, how the Christian representatives acted within the Constituent Assembly. So what was consolidated then, that was then the compromise. The compromise to give up political representation, definitely separate electorates, and as it turned out, also social and economic benefits of reservation. So what was consolidated then, as we said in answer to your last question, were the religious and cultural rights. Effectively, two kinds of rights: the right to a dense set of religious freedoms, the freedom to practice, preach one's religion, and so on, and the rights of autonomy in running of educational institutions. There was also some amount of confusion, perhaps, in my reading of what happened in the Assembly. When the Assembly was debating rights of political representation, and minorities were beginning to understand that these would have to be given up, to my mind, it was not entirely clear to all of them that this was also seen to include their giving up social and economic claims on the basis of backwardness. This emerged a little later in the discussions in the Assembly. And it then became clear that the Assembly was treating these two things as part of the same article, or as clustered together, so that the giving up of one meant that you gave up the other. But there were some discussions in the assembly that indicated that this had not been clear to all the members at the time. So, but we must understand, notwithstanding all that, I would say that we must understand that for the Christians, at least the Christian representatives in the assembly, elite though they may be, their main anxiety in the assembly was the establishment of the secular character of the state, of making that secular character of the state a reality, and in being a part of constituting that. Because, as one of them put it in the assembly, it was on that their very existence as a minority community depended. And understand what was happening at this time, understand the violence, understand the displacement, understand that two countries were being created out of one. There was savagery and brutality on both sides of the border. Given what was happening in Delhi at that time, practically, enormous parts of Delhi were just refugee camps for minorities who had fled from across the border. And in the midst of this tumult, in the midst of this chaos, in the midst of this frenzy, these critical foundational issues were being discussed. So a lot of things happened. There was compromise, and there was in a sense a persuasion to limit oneself to cultural and religious freedoms, rather than insist on a political representation, reservation, and the like. On the other hand, establishing the secular state was something that was of such paramount importance that I think that took precedence in the minds of representatives of perhaps all minorities, but certainly the Christian representation in the assembly.
Professor, and I'm going to probably skip one of your in your next journal article titled "In Search of Fraternity." You had mentioned, and I quote, "the need for fraternity to surmount the heterogeneities, separations, and antagonisms of caste and religion." So if you could probably give us an idea about India's idea of fraternity and at that time and its relation to secularism.
Fraternity is a more complex and a much more wide-ranging idea than secularism, perhaps, Sahil. It has a very important social component, apart from being a political ideal or being a part of state policy or something that the state adheres to or stands for. If I were to speak of what the Constituent Assembly meant when they talked about fraternity, they did not talk very much about fraternity. It came up a few times rather than many times. But what is distinctive is that Dr. Ambedkar spoke at length on fraternity in the assembly. And so if I were to put together and summarize what the Constituent Assembly meant by fraternity, then I would argue firstly that they constructed a principle of fraternity that spoke to the Indian situation. Some of these were critically Dr. Ambedkar's ideas. I'll speak a little bit more about what he particularly emphasized on fraternity. But to summarize what the assembly's understanding was, the idea of fraternity, like the whole preamble of the Constitution, was seen as intrinsically connected to the fundamental rights portion of the Constitution. Right. Your question was on fraternity, and You asked about how it's related to secularism, and as I told you, in my understanding, fraternity is a more complex idea. It doesn't remain at the level of the state. It doesn't remain at a political level. It enters into the understanding of citizenship on the ground, as it were, of how citizens interact with each other on the ground. And in the assembly, those who spoke on fraternity, there were not a lot of people who spoke on fraternity. There was not a lot said on fraternity. But what they emphasized was that within the framework of the divides of caste and tribe, class, and religion, and these divisions and separations were discussed quite a lot in the assembly. Within the framework of those, the work of fraternity at a social level is through accommodation, through the principles of inclusion, through cooperation. So these are the contexts: caste, class, religion, ethnicity, tribe. These become the contexts, the background against which fraternity became important for the assembly as a political category as well as at the social level. So they understood fraternity in terms of the Indian situation of hierarchy, division, and also, of course, at that time, then partition. In fact, the term fraternity was not initially in the preamble of the Constitution, but it was then inserted in the preamble of the Constitution. And very importantly, the line that inserts fraternity in the Constitution is a line that puts emphasis first on the idea of equal self-esteem, of dignity. So fraternity is not seen merely as something uniting the nation, but the uniting of the nation is founded on the idea of the dignity of the individual, that it is only people of equal dignity and treated as such who can come together and form a united democratic nation. That also, in a sense, I think brings out Ambedkar's concern about fraternity. Ambedkar spoke at length, as you know, on fraternity in the closing moments, as it were, of the assembly's work. And he talked about it in terms of liberty, equality, fraternity, the three ideas that come out of the French Revolution and so on. But even for him, fraternity is very grounded in Indian realities. And he argued that without fraternity, the line that he says, without fraternity, equality and liberty will be no deeper than coats of paint. That he put an emphasis far more on fraternity than on these individualizing democratic notions of equality and of freedom or liberty. So I think it is of course interesting that it's very difficult to adjudicate fraternity, and judicial discourses after the Constitution came into place did not make much use of the idea of fraternity. It's not very easy to make it justiciable, as it were. Equality, justice, these are things that are more easily taken up in court arguments and judgments and so on. So in those contexts, I think once again the idea of fraternity comes to the fore, which it did not, of which not much was made in earlier decades in critical judgments, but which were much more focused around ideas of social justice, equality, because of course discrimination, reservation, caste, these were the issues of development, the issues of the day in the 50s, 60s, 70s. But it is only in these latterly or more recent judgments that I think you see something emerging of a judicial discourse, perhaps, that includes the idea of fraternity. That what is of equal significance is the protections of the Scheduled Castes and Tribes Prevention of Atrocities Act. Let us remember that in many of these regions, terrible acts of violence are perpetrated against Dalits, including from those who are Christian. So this is the protection against violence, protection against targeting that the Atrocities Act offers to those who are listed as scheduled castes and tribes is something that the Dalit Christians or Dalit Muslims and so on don't have access to. So apart from social and economic benefits, I think this really needs to be remembered and underlined. But with regard to the second part of your question, I think this raises a larger issue of how we think about the state and how we look at law and policy. In such an extremely diverse and unequal society like ours, state policy has to be in advance of society itself. It will inevitably be in advance of society itself. Surely this would be the case if you thought, for instance, about gender rights, rights of women in inheritance, equality of all citizens, regardless of caste, creed, color, race, and so on. That certain groups face discrimination, already face discrimination, already face stigma, already face exclusion is true, is already true at the social level.
Yeah, I think that would pretty much be it, Professor. Thank you so much for this conversation. You've given us some brilliant insight into constitutionalism and minority rights and how it affects the Christian group particularly.